Good afternoon and welcome. I'm Michelle Thorman, privileged to serve you as the Vice President of the FSBPT Board of Directors. It's a rainy day here in Wisconsin and a perfect afternoon to turn into this presentation led by attorney Jennifer Semko. Attorney Semko is well known to the FSBPT community and has been a presenter at our annual education meetings and will be leading a similar webinar later this fall. She's a partner in the Washington, D.C. office of the global law firm Baker McKenzie, where she chairs the office's litigation and government enforcement practice. Today, she's going to help us grasp the importance of the Chevron doctrine and the impact of the U.S. Supreme Court's 2024 overturning. Attorney Semko, thank you for joining us to explore the Chevron doctrine 1 year later and its importance to regulators and regulatory boards.
Thanks, Michelle. It's good to be here with everyone again. Can't see you, but I know you're there, and thanks for listening to me on this cozy afternoon. Not raining here in Washington, D.C. It's actually very lovely, and unfortunately, I've been trapped inside all day long, but I'll get out there eventually. But Michelle's right. We are here to talk about Chevron deference and its demise last year, thanks to a U.S. Supreme Court ruling called Loper Bright. I know that most of you on this call are not attorneys, so we're going to keep this conversational. I will try my best to make sure that everything's clear. And I think it is important that we all have some awareness of this Loper Bright decision and its implications for not only federal agency action, but more importantly to this group, potential effects on state agency and board decision making. So with that, let me give you a quick overview of what we will cover today. First, I'll give you a spoiler alert with big overview of what we'll be talking about and what the consequences are of this decision. We will also talk about judicial deference 101. What is or was Chevron deference? Why did it exist for 40 years? And we will talk about how that Chevron doctrine, which is really a federal doctrine, was applied or has been applied in the states, in the state court system, which is highly relevant to those of you serving and working with state regulatory boards. We'll also talk about competing perspectives on Chevron deference. It had its fans and it had its detractors. And last year, the detractors won out. And we'll talk about the philosophies of both sides of the coin. Then we will talk about the Loper Bright decision itself. Not a whole heck of a lot to say about the decision. It was very clear in its reasoning and its outcome. And then maybe most importantly, we'll close it out by talking about the fallout from the decision, although it's only been on the books about 10 months, 11 months now, and predictions for the future. Lawyers hate to make predictions, so you won't hear many conclusive statements from me today, but certainly it's an issue we'll be watching, and there are lots of possible consequences to flag for you, and we'll have to see what plays out. So, spoiler alert, what are we going to be talking about today? Well, the decision in 2024 in June in Loper Bright has really changed the legal landscape and arguably the state and federal regulatory landscape more broadly. And that's in part because for 40 years, federal courts applied judicial deference to agency decision-making in certain circumstances, the famous Chevron doctrine. And we'll talk a bit more in detail about how that came about, what it really meant. And many state courts and legislatures over the years adopted the very same approach at the state level. And this went on and on for decades, although more recently, deference was starting to come under fire. It was increasingly being criticized. And all of that culminated in last June's decision in Loper Bright. Chevron deference is no more. What does this mean? for future challenges to federal agency decisions. How is this going to affect state agency decisions, including, for example, state licensing board decisions? Well, it may have no effect at all. It may have a tremendous effect. How's that for a lawyerly answer? It really depends, in part, on what state you're in, and also depends on how things play out over the coming months and years. So some of you may be thinking right about now, boy, I really wish I knew what Chevron deference was. That's why I'm here. Let's talk about Judicial Deference 101. What is Chevron deference? So it's a federal doctrine that came out of a case, not surprisingly, the Chevron case, decided back in 1984 by the United States Supreme Court. And the upshot of the Chevron decision is this: where a law passed by Congress is either silent or ambiguous, the court has to defer to the interpretation given to that law by the agency that is responsible for implementing that law. So if you're talking about the Clean Water Act, courts should defer to the EPA, which is responsible for implementing the Clean Water Act. If there's some element or portion of the Clean Water Act that's either silent or ambiguous. Now, the court does not have to defer if the agency's interpretation is unreasonable, but over the years, that was a fairly high bar to find that an agency's interpretation was completely unreasonable. And the court has to defer, or had to defer, under Chevron, even if the court believes, you know what, there's a better way to interpret this, but the agency interprets it this way. That's reasonable. We'll go with that. That's essentially how the Chevron framework worked for 40 years. So why did the Supreme Court back in 1984 conclude that Chevron deference to agencies was something worth doing? Well, if we look at the language from that court's decision, it basically tells us in a nutshell, in the court's view, judges are not expert in the field that the agency is regulating, and they're not part of either of the political branches of the government. They're not elected like Congress people. They're not elected like the president. The judicial branch at the federal level, at least, is somewhat insulated from the political pressures of the world. And so courts must, in some cases, reconcile competing political interests, but they shouldn't do that based on their own personal policy preferences. An agency, on the other hand, is basically charged with implementing the policy decisions that Congress delegated to them. And so the agencies essentially are allowed to be a little more political, implement the administration, the executive branch's views of wise policy as well. So the court is sort of grappling with the role of the agencies and the executive branch charged, empowered by Congress, versus the courts, which are supposed to be separate and outside of the political pressures. And then the court noted, importantly, that while agencies are not directly accountable to the people, the chief executive is, the president is, and it's entirely appropriate for this political branch of the government to make the kinds of policy choices that the agency would be making if there were an ambiguous or silent statute. And so essentially the court felt it was very important that the agency, the one that's accountable to the people, be the one making the call here, not the judges, not the courts. So, okay, I've told you this Chevron deference is a creature of the US Supreme Court. It's a federal doctrine. What does that have to do with the state court system, state agencies, or state boards? Well, even though it is a federal doctrine, for many, many years, it has often been cited by state courts when they are evaluating state agency actions. And in fact, many states have adopted Chevron either expressly or their courts have cited it approvingly. Hey, we look over here at what the US Supreme Court says about agency deference, and we think that should apply to our state agencies as well. And the courts have reached that conclusion in part because many states model their own administrative codes after the federal APA, the Federal Administrative Procedure Act. And so for many decades, Chevron deference as a federal doctrine had tremendous influence on the state court system, the state regulatory world, and I'll bet a number of you on this webinar today have encountered it in some fashion over the years. How would it be implemented as a practical matter by a state agency or a state court reviewing a state agency? Well, I came across this cartoon many years ago, and it's sort of my comical imagining of what a typical state agency meeting might look like. But more seriously, I thought I would share with you a couple of examples of times when Chevron deference, or at least deference more generally, came into play in the state court system. So let's take a look at the Hensley case out of New York in 2021. You'll remember 2021, we were in the throes of COVID, and the parents of students in the Williamsville Central School District brought a lawsuit challenging the school district's and the state's new COVID rules. And those COVID rules required a hybrid virtual learning setup and also required certain social distancing rules, which largely led them to conclude we've got to go to school online because we simply can't put folks together in a room and meet these social distancing requirements. The parents filed a lawsuit demanding full-time in-person learning for their children, and they argued that the social distancing rules were arbitrary and capricious and not based on real science. And they presented their own expert witness saying, you know, this is not backed up by science. There's no benefit to keeping folks socially distanced. Obviously, the school board saw it differently, and it all went up to court for review. And the court, in making its decision on whether to uphold the school's plan, pointed to deference and noted that the agency, here the school district, is accorded a high degree of judicial deference, especially when the agency acts in the area of its particular expertise. And so the court noted, look, you guys running the schools, you are experts in student health, student learning, effective and appropriate educational methods, not me, the judge, not us, the judges. And so the court applied a good degree of deference, but it wasn't completely in alignment with the school district. And in this particular case, the court actually agreed with the parents about the social distancing issue, in part because the court looked at updated CDC guidance and the expert testimony, but the rest of the parents' claims were dismissed. So the court sort of struck a balance, deferred to the agency, the school district, but didn't completely adopt anything and everything that the school wanted to do. Now, this next example, I think, really hits closer to home for those of you on the call who are engaged in licensing and are on state licensing boards. In the Burke case, again from around 2021, this one's coming out of Maryland, the board decided to revoke a doctor's license after he pleaded guilty to the crime of improperly prescribing certain controlled substances. Now, what The relevant board decision here was that they made the decision to take his license away without giving him a hearing. And they were able to do that under Maryland law if the crime was one of moral turpitude. But arguably, it was a little unclear what exactly rose to the level of a crime of moral turpitude. And that's the question that made its way up to the court. The court, looking at it, said, you know what? The board's decision is subject to, quote, deferential review. What does that mean for me as a judge? I'm going to presume it was a valid decision. I'm going to give great weight to the agency's legal conclusions if they're premised on a statute that that agency is administering, which was certainly the case with the Practice Act that this board was administering. But I'm not going to defer to the agency when it comes to analyzing law, analyzing cases. With that framework in mind, the court upheld the board's disciplinary decision. So maybe some of you have experienced this in your own professional lives when your agency, your board's decisions have been challenged, goes up to the judge, maybe even an appellate panel, and they are considering where to defer to the board and where to make their own independent assessment. Usually facts and interpretation of the ambiguous statute, defer to the board. Analyzing law and cases, preserved for independent review by the judges. One more case, this one out of New Jersey, again, a licensing decision. The Racing Commission denied this plaintiff, Mr. Colasanti, a license to be a stable employee, and they took disciplinary action against him. And this was based on him working with racehorses when he had been prohibited from doing so. I believe he had a past gambling issue, and so he wasn't allowed to be around racehorses, but he did it anyway. He had hearings in front of a board of judges, which is a particular creature of New Jersey law, and an ALJ. They upheld the commission's decision not to license him, and so he sued in court. This made its way all the way up to an appellate court, which noted the deferential standard in New Jersey and said, ordinarily, we should not disturb an administrative agency's determinations or findings unless there's a clear showing that the agency didn't follow the law or was arbitrary or unreasonable. So a fairly high standard. And the court also noted, we accord substantial deference, recognizing the agency's expertise and superior knowledge of a particular field. So again, this shows you that this idea of deference is in part born out of an idea that the agencies, the boards, are the experts in the field that they are regulating, not the judges. And so it made sense for the boards, the agencies, to be the ones to make those kinds of close calls. However, not everybody agrees with that philosophy. And deference has been somewhat controversial for a number of years. So let's talk about competing perspectives on deference. So on the left side of the slide here, we've got the pro-deference folks. Why have people been in favor of courts deferring to agencies? Well, first, one compelling point that the pro-deference side of the camp often points out is this is the way Congress or the state legislature designed it. Congress created this agency, created this board, and delegated authority to them with the expectation that they would exercise their judgment. Deferring to them is completely consistent with that. Another point that the pro-deference camp often touts is that judges aren't experts. They're not brain surgeons or physical therapists or orthodontists. They are not experts in the issues that the agencies are regulating. They're not environmental protection experts, clean water experts. You name the agency, there's going to be some expertise found in that board or that agency. Courts simply don't have that, and the agencies are in the best position to make decisions. The third point is that, boy, the world would be really messy if we didn't defer to agencies. Why? Well, without doing that, courts are going to be making case-by-case decisions. You might have one judge over here deciding that the guy who was involved with the racehorses should not have been disciplined, while a judge over here reaches a different decision. Or maybe a better example, the Clean Water Act, which I keep going back to. You might have a judge in Florida conclude that a certain ambiguous provision means one thing, whereas a judge in Minnesota reaches a completely different conclusion. If they deferred to the agency, you'd have consistency regarding that issue. But if each judge gets to make an individualized decision, you're going to have a patchwork of potentially inconsistent rulings across the country or across the state. And then finally, politics. I read to you some language from the Chevron decision in which the Supreme Court back in 1984 stressed that agencies are accountable to the people, courts are not. And so if you are not deferential to the agencies, then you're pulling out that political accountability, and the judges are somewhat insulated from the accountability for these kinds of policy judgment calls. On the other side, you've got folks who very much don't like deference. Why not? Well, a primary argument that is often touted by that camp is, look, Judge, you have a job and you are punting that job to the agency. And that is an abdication of your authority. You shouldn't do it. Another point of view on the anti-deference side is that we are giving too much power to the executive branch, too much power to the agency, making them the king of everything, and really, again, removing the role of courts to independently assess executive decisions. There's also frequently a criticism of this regulatory state, that if you engage in too much deference, you are empowering a regulatory state that, again, is running the show and removing power from the judicial system, the judicial branch. And then finally, if you're a litigant, a party appearing in court against an agency, the argument is that you are fighting a battle with one hand tied behind your back. You know, I've been on both sides of the equation. I've been in court challenging agency decisions, but I've also been involved in cases where we were aligned with the state or a federal agency. And it is very interesting if the court is deferring to the agency, it is probably the only situation I can think of where you walk into court knowing you've got an extra hurdle because the judge is required to side with the other side unless you can prove their interpretation is unreasonable. So those are the competing views. Now, who had these views? Who were the deference skeptics out there? For those of you who are familiar with our Supreme Court justices, you might recognize these three gentlemen up here. I put them up here because they are the most well-known justices who have commented on deference to varying degrees. Justice Thomas has been on the Supreme Court for quite a long time, not a fan of deference. And in this quote here, this is from a Supreme Court case from back in 2015, so 10 years ago. He was already making some noise about deference. In his view, Chevron deference wrests from the courts the ultimate interpretive authority to say what the law is and hands it over to the executive. So again, not a fan. Justice Roberts, over the years, he's the Chief Justice of the Supreme Court, has been on the court for many years. He's been a little more balanced in his views. In a decision from 2013, he dissented and made the statement here that the judiciary has an obligation not only to confine itself to its proper role, but to ensure that the other branches do so as well. He has expressed an acknowledgement that there is some benefit to deferring to agencies, but he's also questioned that it might go too far in some circumstances. And then last but not least, Justice Gorsuch. Justice Gorsuch has hated Chevron deference, I think, from the day he was born. And I say that only half jokingly. His mother was an EPA executive who I think was challenged by the very ruling that came out in 1984. So he has spoken strenuously against deference for many, many years. This quote I have up on the screen is actually from his time on the 10th Circuit Court of Appeals, well before he became a member of the U.S. Supreme Court. And when he was appointed to the court, that's when folks started to think, you know what, if Justice Gorsuch has his way, Chevron deference is going to die. Sure enough, it took some time, but he got his way. So I've made it clear that the deference skeptics have started to become louder and louder in recent years. And let's talk a little bit about why I say that. So let's take a snapshot from 2018. So a good 6 years before the Loper Bright decision comes out. Chevron deference was raised in defense of federal agency statutory interpretations in 5 U.S. Supreme Court cases that year. How many of those cases do you think ended up in favor of the agency? None. How many ended up with the agency position rejected? All 5. Justice Gorsuch wrote or was in the majority in all 5 of those cases. Now, in those cases, the court did not reject Chevron deference outright, but those cases include some commentary that make it pretty clear that they're a bit skeptical of the doctrine. And the court seemed pretty disinterested in how the agencies interpreted the statutes at issue in those cases. So what did that signal to the lower courts? It signaled that the U.S. Supreme Court was saying, don't defer too quickly to these agencies. Think long and hard about it. So that was the scene 6 years ago. And on the state side, things were also changing as well. In that same year, it was a big year for the anti-deference world. One state, Arizona, passed a law forbidding deference. It amended the State Administrative Procedure Act and instructed courts to decide all questions of law without deference to government agencies. Another state, Florida, put the question up to the people and proposed a constitutional amendment that was passed and took effect in 2019, also prohibiting courts from deferring to agencies. And then 3 state Supreme Court rulings came out that year, in each case chipping away a little bit at judicial deference to agencies. And that was Mississippi, Wisconsin, and Michigan. So again, things are starting to move. In 2021, some other big actions. Arizona enacts another new law. Any appeals of an administrative decision that affects or deals with an agency that regulates a profession or an occupation shall be a de novo trial if that's what the licensee wants. No deference. De novo basically means starting all over again with the appellate body completely reviewing all issues with a fresh eye. That law also made it clear that the court would decide all questions of fact without any deference at all. And questions of law were already dealt with back in that 2018 law that I mentioned to you a moment ago. So if you look at the Arizona governor's website, it makes clear that the political atmosphere that led to this law. He pointed out, or he made the argument, that the new law ensures people working in a regulated occupation have access to due process during appeals, implying that it would not be due process if there was any deference. And it ensures that a regulated party believes they've had an adequate opportunity to be heard. If they haven't, their appeal will be heard anew. So again, this feeling that agencies were somehow not being fair, and that only a fresh review by a court would give the regulated professional the rights that they are entitled to. That same year, 2020, around that same time in 2020, we had a big decision come out of Arkansas, where the Arkansas Supreme Court clarified some older cases on the book and addressed deference, even though, and this is really interesting, neither party in the lawsuit asked the court to do that. The court was so interested in commenting on deference that it did so without either party raising the issue. And the court held that agency interpretations of statutes would be reviewed de novo, no deference. And that if a statute is ambiguous, sure, the court can take into account how the agency interprets that statute, but the courts don't have to defer. It's just one of many interpretive tools that the court could use. Why? Because it is the province and duty of this court to determine what a statute means. So again, very much tracking that anti-deference, those anti-deference points that I went through a few moments ago. So we've got things building in these years before Loper Bright. During this general time period, how many states expressly increased the degree of deference to agencies? Not a single one. There was no real push in the other direction. States were either holding firm with their existing approach or slowly chipping away or completely doing away with judicial deference. Now, there were some states that had a little difficulty figuring out how they wanted to handle the issue. I mentioned just a couple here. In Indiana, for example, their Supreme Court in 2018 says there is no tie goes to the agency standard. We're not going to tilt the balance in favor of the agency. But then the very next year, the court endorsed deference, which caused at least one judge on the court to really protest. So a little bit of inconsistency happening during that time period. In Kentucky, the courts in Kentucky had a very strong tradition of deference until 2013, when a Kentucky Supreme Court decision said, you know what, you're not bound by agency interpretations. But then a few years later, the court says, hey, we give substantial deference to agency construction. But then the next year, the court declared deference extends only to fact-finding, not law. So again, a bit of a struggle here by some of the states on how they want to deal with agency decision-making and how much deference there should be. All of that builds up to the summer of 2024 when we have the Loper Bright decision. So what did Loper Bright do? Well, it overruled Chevron after 40 years in a 6-3 vote of the U.S. Supreme Court. In the majority were Justice Gorsuch, Justice Roberts, and Justice Thomas. No big surprise there. Why? Well, in the majority's view, the Chevron doctrine is fundamentally misguided. They didn't mince words. They felt that deference is inconsistent with the Administrative Procedure Act, which opens up agency action for judicial review. And the court pointed out that the APA directs courts to decide legal questions by applying their judgment, their own judgment, not applying the judgment of the agency that's under review. And thus, under the APA, it remains the responsibility of the court to decide what the law means and whether it means what the agency says it means. And what about this issue of judges not being brain surgeons, judges not being experts? The agencies are experts. Well, the court didn't find that that was sufficient to justify deference. And the court said Congress expects the courts to handle technical statutory questions. And the courts benefit not just from the agency's point of view, but also from the briefing filed by the parties and amicus curiae, friends of the court. So basically, the court can take in the expertise of anyone and everyone, and the agencies are not entitled to greater weight in terms of their role, their beliefs, and their expertise. So what do we do now is really the question. What are the implications of this Loper Bright decision? I think it's worth remembering that Chevron only applied to agency interpretations of ambiguous law. If the law is clear, if the agency makes a decision based on clear law, that's one thing. Chevron came into play where the statute was unclear and the agency was engaging in some level of interpretation that could be disputed. So in that sense, we shouldn't overstate the importance of Loper Bright. I have in the first bullet a note that Skidmore deference is still available. I don't want to get too into the weeds on the law, but the point there is courts can consider agencies' interpretations when it falls within certain other circumstances. The court under Skidmore can give some deference or can weigh factors like the agency's reasoning, its consistency with prior agency actions and expertise. But this is not an automatic form of deference. The agency's got to persuade the court that it's right. So Skidmore still exists, but that old Chevron way of thinking, hey, judge, you are obligated to defer to the agency, that is completely gone. So again, don't want to overstate the importance of Chevron's death. Congress did, in some circumstances, clearly grant power to agencies, and that is still intact. Federal courts also must still defer to discretionary agency action and agency fact-finding for the most part. So it's not a complete evisceration of deference to agencies. It's also important to keep in mind that the Loper Bright decision doesn't have the effect of going back and overturning all the old court decisions that relied on Chevron. Now, of course, there are going to be plaintiffs out there looking for ways to go challenge those old decisions, but they're not automatically undone. Some have suggested that the Loper Bright ruling is going to cause agencies to become a little more conservative with their rulemaking because they know now that courts may not defer to their decisions. Maybe some agencies are going to have to lobby Congress or will want to lobby Congress for clarity in statutes or more authority. And maybe this means that when an agency does make a decision that it thinks might be subject to challenge, it's going to provide a more detailed explanation of its reasoning because now it knows it's going to have to work a little bit harder to convince the court to agree that its decision was correct. But then this begs the question, what about the states? How will the states respond to this decision? Again, I think it's worth reiterating. Remember, Chevron deference only applied to agency interpretations of ambiguous law. So I think the effect of Loper Bright is really going to depend on the state. As you saw, a lot of states were already trending away from deference. Some outlawed it outright, others chipped away at it. And so if you're living in or working in a state that has already rejected deference, arguably, Loper Bright has no impact at all. Those states that for years still have recognized Chevron-like deference, the Supreme Court ruling is not going to, by itself, undo state law, undo state court rulings. But it's probably going to make those old rulings that were based on a Chevron philosophy a little less persuasive. And it could open the door to new challenges to old, settled precedent, old, settled agency decisions that have been on the books for a while. The door may be open for someone to come in and bring new challenges to those. And in terms of predictions, again, lawyers don't like to make predictions. And again, Chevron only applied to agency interpretations of ambiguous law. But some are predicting that this signals the beginning of an overall shift of power from agencies to courts. I think that might be a little bit of an overstatement, but it really remains to be seen, and it may depend on the jurisdiction. Some are predicting, and I think this seems fairly likely to come to fruition, that there is going to be an increase rapidly in the number of challenges to agency rules and actions. Like I mentioned before, things that were previously settled, agency interpretations of statutes that have been around for years, now might be reopened if that agency decision was based on any kind of deferential point of view. And remember when we talked about the pro-deference camp, one of the points they frequently made was that if you don't have deference, you might have inconsistency in your court decisions. If the courts are independently making judgment calls, not deferring to agencies, you're going to risk having a decision go one way in Florida and another way in California. And that may certainly be the case. And we may see more judicial decisions that are going to require courts to step in and play a little bit more of a role of an expert. At least some have argued that. I actually think what we'll end up seeing is the court taking in more points of view from more sources now that the court's going to have to independently assess the expertise of the agency. And finally, because so many states have already moved away from a deference doctrine, the decision may have absolutely no impact at all in some states and some jurisdictions. So I will stop there. That's my overview of Chevron deference, my eulogy to Chevron, and the closest I am willing to get to any kind of predictions as to where we go from here. But I think for state licensing boards, I don't think it will have a tremendous earth-shattering effect on you right away, if ever. And I do believe, particularly in the professional licensing space, courts, even if they're not expressly deferring, are still going to give a great deal of respect and consideration to licensing board determinations, so long as the court thinks that it's a reasonable point of view. And with that, I'll pause and see if we have any questions or comments. I would be particularly interested in any comments from those of you who've dealt with deference in the past, maybe if you've even already seen some changes in your own state.
Jennifer, that was excellent. And coming from someone who's not a lawyer and doesn't play one on TV either, I understand this a whole lot better. And again, let's open up the floor for those of you who may have had some personal experience with this. Sandy writes, would you expect, if not anticipate, most challenges are likely, whoop, I missed it. My little chat bar went away.
Oh, mine's there. I can read it. Would you expect, if not anticipate, most challenges are likely to come from individual licensees or applicants? If we're talking about just the world in general, I think most challenges are going to come from highly sophisticated groups that have had agency rules or interpretations on their hit list for a long time, and now the door is open to come in and try and get those agency rules and regulations shot down. For you all, I think you can probably expect most licensees or applicants who are faced with a denial of a license or disciplinary action to be working with their lawyers to think long and hard how they can work this into their legal arguments. Hey, I shouldn't have been disciplined, and you don't need to defer to the board when it said I did X, Y, and Z. I really don't think this decision is going to make a seismic shift in those kinds of determinations, in part because, again, it's a federal decision. In some states, it's completely irrelevant. But even if you have a state that says, well, because of this decision, we're not going to defer to agencies anymore, I still do believe courts are going to be quite respectful and will give very careful consideration when you're talking about professional licensure. There's an additional comment from Sandy. For example, immigration attorneys who are supporting international applicants in terms of regulatory boards. So if I understand your question, I think, as I mentioned a moment ago, if you do have immigration attorneys working with applicants, trying to argue that a board should have, say, granted a license or should have recognized a certain immigration status or should have honored an applicant's foreign education and didn't, I think absolutely you can expect them to add this as yet another argument when they go to court to challenge the board's decision. Hey, judge, you don't need to defer to what the agency said about what is an equivalent foreign education. You don't need to defer to what the board said with respect to my client's qualifications for this license. And depending on your state, that may or may not be true. But again, at the end of the day, I do think courts are still going to give significant consideration to a licensing board's views on that. The court may be more willing than in the past to hear what the immigration attorney and the applicant have to say about equivalency of foreign education or qualification for a license. But I do continue to believe boards will still be heard on this for sure.
Thank you for your question, Sandy. Others have comments or insights relative to this important issue?
My email and phone number are up here. If you think of a question later, shoot it over. Happy to keep the conversation going.
Well, then I'm putting you on my speed dial, Attorney Semko. This was really instructive, and I'm kind of a geek when it comes to listening to hearings and cases that are argued before the court. I know now what I don't know. This has been really helpful. So thank you, and thank you for all who are participating in the webinar today. Please refer back to the FSBPT website for other webinars that are going to be coming up. And remember, Attorney Semko is going to be presenting again this fall. We look forward to seeing any of you who are delegates or administrators at our Leadership Issues Forum come this July. So goodbye for now. I wish you all continued success in the important work you do as regulators.
Thanks, everyone.